I just invite you to, it's a picture, so I cannot go through because the internet doesn't work very well, or the web page of the Commission doesn't work. I will invite you just to visit the page, because here you will find a lot of information. You will get not only the different instruments, the current composition of the Commission. We have only 7 commissioners that represent not the countries, but themselves. They are independent experts elected by the General Assembly of the OAS. But also you will find in this corner to the left the latest reports. Country reports, but also thematic reports. And the reports are fantastic. So you have a really, really well thought report, because the Commission since many years has introduced rapporteurships. So each commissioner of those 7 have the mandate to be special rapporteur on a particular matter. Therefore, you have a special rapporteur for indigenous peoples, you have special rapporteurs on child rights, on LGBT, you have a special rapporteur on fair trials and judicial issues, so different special rapporteurs. And they have developed fantastic literature on the standards within the region. But also you have country reports, for example here on Colombia, Through Justice and Reparation from 2013. So if you want to know more, go to the webpage, and the information is available in English and in Spanish. The other 2 official languages of the OAS, which is Portuguese and French, are less utilized in general, but there is still also information in Portuguese and French. But most of them is in Spanish and English. Any question related to the previous session before we go into the new session? Question, comment, or curiosities that you would like to discuss? About the commissioners, the mandates, the different mandates based on the convention or on the declaration? Yes, please. We have another microphone somewhere. Over there.
Hi again. I was wondering, my name is Aykut.
Nice
from Turkey.
Yes.
Nice. Yeah. I was wondering how the appointment of judges works. For instance, you said that some countries didn't sign the convention. These countries, do they have a right to appoint judges for the court?
Mm-hmm.
Thank you.
Very good question. Yes, the answer is yes. Judges need to be national from the OAS. Not necessarily from countries that has ratified the convention. Therefore, for example, the first, one of the most important judges from the beginning was Judge Burgenthal, and he was an American judge from US, and US is not part of the convention. So, but they need to be citizens of the OAS, and they are elected by the General Assembly of the OAS. So state members elect the judges. Each country proposes a term of 3 judges, and in general they follow a geographical distribution and a linguistic distribution in order to have judges from the North America, Central America, the Caribbean, and South America. Gender distribution is also an issue. There's always more men than women, but countries are encouraged to propose at least 1 woman within the 3 judges that they offer to the General Assembly. And of course, judges are independent, and the only requirement that they have in order to be elected as a judge is to have high moral capacity and knowledge on human rights, and to have the competence to be able to be appointed to the highest judicial position within the country, independently if they are professors or former judges or diplomats, but they have to have that capacity. But they don't serve as representatives of the country. Their mandate is independent, and at the difference with the European Court of Human Rights, they serve for 6 years with the possibility of a re-election. In the European Court of Human Rights, they serve nowadays only for 9 years without re-election. And that has been criticized. There is also a possibility to appoint an ad hoc judge, but that's, if you're interested, I can tell you later. The commissions are also 7 commissioners, and they are also appointed in the same way by the General Assembly of Areas. Any other question, comment? No? Otherwise, this is the web page of the Commission. I recommend to visit and to explore more. Let me see if I can change now the presentations. Go to this one. Very good. So now, what we will do is to get a little bit into the jurisprudence of the Inter-American Court of Human Rights, to understand how the court interpret the rights enshrined within the convention, which are the methods of interpretation, and how that has affected the development of a targeted minority right protection. So, the idea of the discussion, I don't know if we will manage to discuss all of this, but will be first to focus on the interpretative method of the court, second, on the way that the court has integrated international human rights law in order to provide a harmonious protection to human rights. Third, the centrality of the principle of prominent that has been discussed a little bit before. And finally, how that has affected the development of the jurisprudence in connection with sexual minorities and indigenous peoples' rights. The importance of this is that this interpretation could be applicable to any case, and therefore to the protection of other vulnerable groups or minority groups. That's why I prefer to start. So how do we interpret rights in the way that will be conducive to an effective protection? And then you can use that as a tool. The importance of this is that this is applicable not only within the Inter-American system, but you can use it as an interpretive tool in connection with other systems. Because at the very end is how we interpret human rights. That is the question that we will try to answer during this session. First of all, this is the introduction of the topic. First of all, we need to interpret human rights as a system, as I said before. We should not interpret human rights as a cumulative aggregation of instruments that are not interconnected with each other. We need to interpret them as part of one system. And I will tell you, I will give you, if I manage not to destroy this, I will give you an example that make us an idea why we need to interpret human rights in an integrative manner. Can you see the whiteboard here? So, let's say that we have here in the middle, well, it does look like an alien. It's supposed to be a human being. One of my qualities is not being a good designer. So I'm sorry for that. But I would say that's a human being. So the centrality of a human being. Can we agree on that? Very good. So we don't know anything about this person. Only that it looks like E.T., but it's just a human being. We don't know if he's a child, we don't know if he's a woman, we don't know anything about it. So let's start putting some characteristics to this person. If we're just looking at the person, we will say, well, all human rights treaties maybe will be applicable to this person. But let's say that we put another human being nearby. Then it's just not just a human being. Now it is a child. Very good. So we have one instrument that is designed for the specific protection of the right of a child, which is the Convention of the Right of a Child. So we'll put it here. The Convention of the Right of a Child. So if we want to know which are the rights of that child, I said, well, let's read the Convention of the Right of a Child. But what happened if we put other characteristics to this child, it's a female child. And as a female child, we can apply another convention to it, right? The CEDAW. The CEDAW convention. But what happens if this child has an additional characteristic? Has some problems with mobility, so a disabled child, a child that is a person with disabilities. So we apply the Convention on the Right of the Person with Disabilities, right? And we can continue in that way. So the person, the same person, the situation, for example, of that person that is faced within the school and therefore connected with the right of education, we will find provision on that right on all of these conventions that claim the protection of the same subject, a child. But also, we have, for example, Article 13 of the International Covenant on Economic, Social and Cultural Rights, right to education. So all of those instruments will deliver, to a certain extent, a specific protection to a child. And we cannot take them separately. We have to take all of them as a system for the protection of that particular human being. And that works at the universal level, but also at the regional level. So when you will have a particular issue on the right of education or connected with any other right, the first things that the interpreter should do is to find which are the instruments that are relevant for the protection of that situation. And could be more than one. And you have to interpret all of those as part of a system. And if we have some contradiction within them, as some of you said this morning, well, the interpreter will have to resolve those contradictions. How to resolve those contradictions? Well, remember the pro homine principle. The interpretation should not lead toward a less effective protection of the right involved. Should always lead to a more enhanced protection than a less effective. And to an interpretation that will deliver an effective protection to the right involved. And that's what is called in the jurisprudence of the Commission and the Court, effect util. So it's a teleological interpretation because it's always focused on deliver the most effective protection to the rights of the individual involved. Which is connected with the pro homine principles in a sense that is a principle that rule the most favorable most favorable to the human being. So these are the main principles that we will see in the jurisprudence of the court and in the recommendation of the Commission. Any question on this, or comments, or additional ideas? No? Let's move forward. This is a little bit, I will not spend a lot of time on this because it's a little bit legalistic. For our friends that are coming from other disciplines, will be difficult to understand. But, yes, the child is nice, but it's not transparent. Well, I can continue like this, but not for a long time. Thank you, Marco. Thank you very much. You see, human rights promotion and protection has its challenges, including moving the white words. So, this is a little bit legalistic, but it's important to remember that international human rights law is part of international law. And as part of international law, it's followed, and our professor of international law is looking at me and saying, what are you going to say? It follows the principles of international law, with some exception, but it follows those principles. And one of the most important principles is how we interpret international law. And in that sense, I recommend to read the Vienna Convention of Law of Treaties from 1969, a foundational instrument in international law, and in particular two articles, Article 31 and 32. And those two articles tell us how to interpret international law. And to make the story short, Article 31 says that in order to understand the meaning of the words of a text, if you read the convention you will find a lot of words there, in order to understand the ordinary meaning of those words, you need to focus on the object and purpose of the treaty. In other words, to interpret the terms of a treaty under the object and purpose of that treaty. What does it mean? Well, if you have a treaty for the protection of the right of a child, the purpose of that treaty is to deliver a protection to that child, to protect a child. That's the purpose of a treaty. If you have a treaty for the protection of rights of women against discrimination, that's the object of the treaty. In other words, human rights treaties has one particular purpose: effective protection of the rights. It's not just a declaration, it's just to deliver effective protection. So when you have a doubt how to interpret, for example, the term family, the term child, the term domicile, the term life, as we discussed it this morning, well, the interpretation needs to lead toward the realization of the object and purpose of a treaty. In this case, effective protection of human rights. For example, in one advisory opinion, the Inter-American Court of Human Rights, this is a very important advisory opinion on the right to information and consular assistance from 1999. It says that the principle of effectiveness means that the interpretation must be done in a way that the system for protection of human rights has all its appropriate effects, generate its appropriate effects. Remember always that, object and purpose of the treaty. And this is, I will tell you if we have time a little bit more about this advisory opinion, because it was used by Mexico requesting the Inter-American Court of Human Rights to issue an advisory opinion on the matter of the protection of Mexican citizens in the United States subjected to capital punishment. Advisory opinion is one of the competences of the court that is not in a contentious cases. So it's not Alejandro Fuentes against Mexico or against the United States. It's about how we interpret the standards within our system. So Mexico wanted to know how to interpret, for example, the protection of right to life under the Inter-American system, under the American Declaration, under the American Convention, with one particular purpose: to protect Mexican citizens that are subjected to the application of death penalty in the United States. So a very instrumental use of the Inter-American system for one particular diplomatic purposes. If you want to know more about what happened in this case, read the advisory opinion, but also read the case of Avena versus United States that has been adjudicated by the International Court of Justice in 2009, 7, don't remember, which is connected with this case. If we have time, I will come back on this. So, this we can, even in the case that there are always the possibility to apply supplementary means of interpretation, I will not go into that, but even in those cases, for example, when we read the travail préparatoire, the preparatory work of a treaty, need to be interpreted in line with the object and purpose of the treaty. Finally, and here we come to the systemic interpretation, when we interpret the treaty, remember always to do it according to today's conditions. Why? Because if the object and purpose of the treaty is to protect human rights, rights are protected in the context. They are not protected in abstract. So, let's say right to life. We do not protect right to life as an abstract exercise, but right to life in the city of Cordoba in Argentina in 2018. It's a contextual application of right to life. The same with all other rights. So when we interpret what does it mean right to life in this case today, we have to take into consideration today conditions. Not how right to life was interpreted in 1969 when the convention was adopted. And this is a absolutely unanimous interpretation between the Human Rights Committee, the European Court of Human Rights, the Inter-American Court of Human Rights. All of them say the same. Human rights need to be interpreted in evolutionary form. As how do we interpret today according to today's conditions in society. And that is key for the protection of minorities, if you think. Because imagine sexual minorities. In 1950, when the European Convention of Human Rights was adopted, or 1969, when the American Convention was adopted, even the sexual intercourses between consensual adults of the same sex was still considered a crime at that time, in both continents. So today, society has evolved from the way that those actions were perceived. So in today Europe, or in today the Americas, the way that partnerships, relationships are interpreted is different from what happened 40, 50, 60 years ago. So that's why we need to pay attention to how the conditions are today. But also how we interpret the human rights system today. How we interpret the other human rights instrument, as we saw in that picture, today. What does it mean today, the protection of discrimination against, the protection of the right of women against discrimination, the protection of the right of person with disabilities? How we interpret that today? Any question or comments about this? And maybe, or something that you want to share? No? So this is the case that we were talking this morning. Artavia Mauricio and others, in vitro fertilization versus Costa Rica, 2012, where the court has interpreted, according to today's conditions, what does it mean right to life. So if you're interested to know more, the English version is already available, so you can download it from the webpage of the court. Article 29, we discussed it this morning. So, non-restrictive interpretation. In order to provide the most effective protection to human rights, we need to interpret the convention in the way that will not limit the protection afforded by national laws or other treaties. That means that if we have a case of involving the right of a child under the American Convention, we cannot provide a less protective decision as provided by the Committee on the Right of the Child, the Committee of the CEDAW Convention, the Committee on the Right of Persons with Disabilities. Because that will be against Article 29. So, as you see, all of these elements goes toward the same direction, effective protection. In other words, we need to interpret the case under the instruments or the system on which the convention belongs, which is human rights system. Again, Artavia Mauricio, in vitro fertilization versus Costa Rica. I will go a little bit further in this. This is something important for the protection of minority rights in the region, because most of the cases that was developed by the Inter-American Court of Human Rights was based on comparative analysis of other instruments within the universal system. If we take, for example, the case of indigenous people rights, the rights recognized in the UN Declaration on the Right of Indigenous People and in the ILO Convention 169 on the right of indigenous and tribal people was absolutely relevant in order to interpret the American Convention. Without those instruments, the court will have been unable to arrive to the same conclusion. That means that when the court interprets one right of the Convention, make references to all instruments available within the system that could provide clarity to the text of the Convention. Could be a declaration, could be a treaty, could be a resolution, could be even a statement of purposes by a given state. The important is that what the court does is to establish what is today international law. And that gives something in connection with the value of declarations. So we discussed this morning the difference between declaration and treaties. What can be used the declaration for? Well, we can use it in order to provide content to the rights recognized in the Convention. Especially in the case of indigenous people rights, for example. We don't have many instruments in international law, right? We have the Declaration on the Right of Indigenous People, 2007. We have the ILO Convention, but the ILO Convention has been ratified only by 22 countries. Most of them Latin American countries. In Europe, only Denmark, Spain, and Norway. 3 countries, right? So, not many. 1 in Africa and 1 in Asia, I think. The rest, Latin American countries. So, how we make those rights effective? Well, the way to do it is to interpret the universal right recognized within the covenant or within the regional instrument under the light of those declarations. Because when state declares something, they are declaring what they interpret, what is their interpretation of international law today. When they adopted the Declaration of the Right of Indigenous People, they said, today, these are the rights that indigenous people have. And that has a legal effect. It's not just a mere manifestation. It has a legal effect because it's part of international law. So when you will construct the protection of minority rights, remember that you can use all of those instruments in order to provide content and determine which is the scope of protection of right to life, right to private and family life, right to freedom of religion, freedom of expression, etc., etc. This is another very interesting advisory opinion from the Inter-American Court of Human Rights. In the case of the juridical condition and rights of undocumented migrants, number 18, where the court developed which is the standard of protection of undocumented migrants within the region. But if you are interested in deliver protection in Europe to the same sector of population in situation of vulnerability, undocumented migrants, this is a very interesting document for you to read. Because this advisory opinion is based on the interpretation of international human rights law, not only on the instruments of the Americas, but the entire human rights system. Again, systemic interpretation of human rights law. So you can draw comparative analogies and apply on your own interpretation of the European system for the protection of undocumented migrants. It's available in English, of course. Another advisory opinion interesting for you could be this one on the right and guarantees of children in the context of migration, quite recent, from 2014. Again, focusing on the migration process, but on delivering specific protection to unaccompanied children within migration processes. And here, in this advisory opinion, we found a very clear indication of how the pro persona principle, or pro homine principle, works for enhancing the protection of those in situation of vulnerability. Because the interpreter has the obligation to pay attention to those conditions of vulnerability in order to match the effective protection that the system delivers to the condition of the person. The protection is not abstract, it's concrete and in the context of the situation of the person. Any questions so far? Please. Oh, thank you.
I agree with you that we have the systemic interpretation of the international obligations of states, but what do you think about I don't know how to say in English exactly, but justiciabilidad?
Justiciability.
Directly or indirect. I mean the interpretation of, for example, the right of life in indigenous cases, according to the Inter-American Court of Human Rights ruling.
Yes. Well, let's start from the last part of your contribution. So the ruling of the Inter-American Court, as the ruling of the European Court of Human Rights, as the ruling of the African Court of Human and People Rights, are binding. Right? So the rulings are binding. That means if the court delivers a judgment in a particular case, state authorities are obliged by the obligation that they assume under the convention to fully implement the judgment and all the measure of compensation and reparation. That means that all the rights within the convention are justiciable. This means that you can get protection through to a judicial system, and therefore to a right to a binding final decision. The convention, as I mentioned before, does not mention any specific right of minorities, including indigenous people rights. Indigenous people are not even mentioned within the convention. We have now one new instrument, 2016, which is the American Declaration on the Right of Indigenous People, but this is a declaration. The same as the declaration that we have at the UN level. It's a declaration. Are those rights justiciable? Can we claim those rights, in other words, before a court, before the Inter-American, before the Commission and after the court? Well, not directly, but yes, through the convention. Here is the point of the interpretation. Because indigenous peoples are any other person, they have right to life. They have the right to marry. They have the right to cultural life. They have the right to property. They have the right to religious freedom, etc., etc. They have the same rights, in other words, because they are humans. So this is a confusion that in general we found not only in state authorities, but also on activists that forget that human rights protect indigenous people. So when you look for protection, the first way to look at is the entire human rights system and the entire binding obligation that the state has assumed as universal rights. Then we can interpret those rights under the light of the specific instrument that has been developed, taking into consideration their cultural diversity. The different declarations, the ILO conventions, but focus on what is binding, because that's the entry point. And then forcing interpretations that are in line with the effective protection of their diversity. Principle of effectiveness again. The right to life, or have a life in dignity, of a person belonging to an indigenous group will have a different meaning than the right to life, or life in dignity, of a person living in a metropolis, or not part of that group. Because dignity, as a legal standard, is also something that is partially connected with each individual. What is a dignified life for an indigenous person could be will have a different meaning than a dignified life by a person belonging to the mainstream community in a metropolis. I will come back later on that. But as a matter of interpretation, remember to allocate indigenous people rights or any other minority rights within the system, because that will reinforce the claim. And you will have much more possibilities to win that claim as part of your strategies for advocacy. Even if it's not a judicial case, even if just, let's say that you want to advocate for the protection an awareness of the rights of a given group? Well, connect it with the entire human rights system. Don't disconnect it, because then you will vacuum your claim from the strangeness of that system. Any other comment or question in connection with this? No? I have to keep an eye on the clock, otherwise we got until 12. 12:30. 12:30, very good. Let's go into one particular case just as an example of how we can interpret the rights for the protection of a particular group. And that is the case of Atala Rifo versus Chile, 2012. As you see, all of these cases are coming in a particular momentum. 2012, 2014, it was a momentum. And everything started, I will say, since the 2000s. And that is not casual, but causal, because the interpretation of the right in a way that provides better protection to minorities started with a new understanding of international human rights law of the judges themselves. I've been following the jurisprudence of the Inter-American Court since many years, and it was a moment in the jurisprudence of the court that it happened a change. And that was connected with one person. There are others that influenced the jurisprudence, but I will say that that person was very influential in the development of the jurisprudence of the court. That was a particular judge. His background was international law, professional in international law. He was appointed as a judge, and he took that as a possibility to develop international human rights law in the region. By using the judgment as a tool for developing the international law. Those coming from Latin America, I think they already know to whom I'm thinking. And he was a judge appointed by Brazil, appointed by the General Assembly for years, but he was Brazilian. He's still Brazilian, and he's Judge Cansado Trindade. Nowadays, he's a judge at the International Court of Justice. If you ever had the possibility to read a judgment in which he has taken part of, you will find that he has a very keen inclination to write separate, concurrent, or dissenting opinions. And those opinions has the volume of a book. So you can find dissenting opinions of 70 pages, 80 pages. In one of the first judgments that he intervened in the International Court of Justice, he wrote a partially dissenting opinion of 160 pages. And that's because he assumed, as his role as a judge, the obligation to develop international law. He's a professor, he used to write, to teach, and to develop that awareness. So, if you want to really learn how you can interpret rights, never forget to read the separate concurrent or dissenting opinions. Because you will find a lot of material that can be used for the development of your understanding of the jurisprudence in those opinions. So he started in 2001 as a judge, and he became the president of the Inter-American Court in 2005. And during those years, you will see a rocket development of the jurisprudence for the protection of minorities. Because he introduced this way of interpreting international law to the other judges. And he was able to convince them that this was the way to go. He finished his mandate, but the court continued the same path. And today, the court arrived to conclusions that never happened in his time, but applying the same method of interpretation. So,
Excuse me,
yes,
what's his name?
Antonio Augusto Cansado Trindade. Cansado Trindade. Yes.
Thank you.
Sorry.
Yeah, just thought it was an ICJ.
Cansado. This is the C with the Sevilla.
Yeah.
Cansado Trindade. So a person could make a difference. That's the learning that we can take. So what you can do by interpreting international law in a specific manner, could influence others. So never forget that. I forgot where we were. One thing takes to another thing. Anyhow, so that's how this jurisprudence developed. That was very, very interesting for the development of indigenous people. I will come back to the indigenous people cases after this. I will come back to that. But let's go back to the development of the protection of sexual minority rights. Until the 2010s around, so Latin America was not a very friendly place for the recognition of sexual diversity, if you want. With the exception of, in the Americans, with the exception of United States and Canada, it has been traditionally friendly, not necessarily in the recognition of specific rights, but the society has been traditionally friendly. Latin America was not. But something started to change in the late 2000s and 2010s and after. With the development of some local developments in some of the countries. Argentina, Brazil, Mexico, Uruguay, Colombia, they started to develop the rights recognized to same-sex partners, to recognition of gender identity, etc., etc. So it was a national development. But other countries still remain quite reluctant to that development. That was the case of Chile. A very traditional society. Chile has been, because it's on the other side of the Andes chain, very high chain, has been quite traditional, remained quite traditional since the beginning of the colonization. And in Chile, in 2003, there was a judge of one of the high courts in Chile that introduced a case that finally arrived to the Inter-American Court of Human Rights. That was Ms. Atala Rifo. She was working in the judicial system as a judge, but she has 3 daughters and she divorced, and then she restarted her life with a new partner. But that partner was from her same sex, and they start living together, having the custody of the 3 kids. But then the father of those 3 kids, her former husband, complained that the current family situation in which those 3 kids were living was not conducive for the well-being of the child, of those 3 children. And he went to the judicial system in order to seek the custody of those 3 children. And at the very end, after 2 negative responses from the judge of first instance and appeal, the Supreme Court of Chile gave him the reason and provide him with the custody of the 3 kids. Of course, that was not what Ms. Atala Rifo was seeking, and then she complains that it was discriminatory based on her sexual orientation and sexual identity, and the case arrived to the Commission and then to the court. And in 2012, we have the decision of the Inter-American Court of Human Rights in this case. And was the first case dealing with this issue, dealing with sexual identity and sexual orientation. And here, one of the reasoning given by the Supreme Court of Chile, the judgment was from 2004, it was something that we discussed this morning. So I said, well, here we have 2 different interests. The interest of family life of Ms. Atala Rifo, that want to develop her family life with a new partner from the same sex. But also we have the interest of the children. And that means that we need to pay attention to the best interest of the child. And the Supreme Court said that, well, Ms. Atala Rifo put her own interest over the interest of the children. She prioritized in this balance of interest her own interest. So she didn't pay enough protection and support to the best interest of the child. But also, in connection with that, the fact that she put her interest on the top of the interest of the child means that she didn't pay enough attention to the risks that she was subjected the children by offering them a confusion of sexual roles, a confusion of gender roles, and hijacking their integral development. Based on this reasoning, the court conclude that the children living with Ms. Atala-Risco will be at risk, and therefore provide the custody to her former husband. What do you think?
So you say 2004, sorry, but then you say that the judgment was
2012.
Yeah.
Yes, but this is from the Supreme Court of Chile, and the judgment is from the Inter-American Court of Human Rights. That gives you an idea how long is the process. 8 years, 2004 to 2012. When the Inter-American Court of Human Rights finally the judgment, well, children were almost adult.
And it's a relatively recent.
Yeah. Yeah.
Shocking.
Yeah, and 8 years means a lot, because during all of those 8 years, of course, the decision of the Supreme Court of Chile was enforced. That means the children were with the father. So, going back to the principle of effectiveness, late justice is not justice.
Sorry, let
Yes.
me just understand the concrete, if there are no other
Yes, then we
questions, the
come back.
concrete situation. So the judgment came in 2012,
Yes,
and up to that point, the children lived with the mother and her partner.
no, with the father.
Yeah, after 2004, they lived with their father,
Yes.
and then they continued living.
No, then they came back with the mother. At the very end, in 2012, when the judgment of the Inter-American Court came out, overturned the judgment of the Supreme Court.
That's what I didn't get.
Yes, because I didn't say it.
Yeah. Oh, yeah.
You are going too fast.
Yeah. No.
Okay.
I would have been flabbergasted
But you
if
see,
it didn't open.
but it's there is a temporary gap between 2004 and 2012. And that's mean, and we go to the two of you, and that's mean that to go into the regional system in order to seek redress and justice could take a very long time. And during all of those years, well, the judgment of the Supreme Court of Chile was enforced, because that was the final decision for the national judiciary. And until the judgment of the Inter-American Court will came, that is what the national authorities should enforce. So that's mean that we have a problem, systemic problem on how long it takes for the regional system to provide the final decision. But that's it's a parallel discussion. Yes?
I understand what you explained about the two interests, the interest of the woman and the interest of the children, and how they were supposedly conflicted.
Yeah.
But I'm just wondering, did the Supreme Court analyze why it posed a risk to the integral development of the children, or it was just that they accepted that very traditional environment and context? Was it analyzed, those risks?
No, that was part of the criticism of the Inter-American Court to the Chilean Supreme Judicial authorities, because it's important to understand that the Inter-American system is not a court of fourth instance. So here we are not discussing who is a better guardian of the children. That's something that national judicial authorities should do, or national authorities, depend. But it's not for the court to decide why it's better that children will go to the mother, or why it's better that children will go to the father, or if they have to share. It's not a court of fourth instance. But the competence of the court is to determine if the decision of national authorities was in any case in violation of the convention, or not. So, control of conventionality, which is called, which is not the same. And in this case, what the court said, that going a little bit ahead, is that national judicial authorities base their decision not on particular specific evidence. For example, on the capacity of the mother or incapacity of the mother to provide a conducive environment in the family conditions that she was living, but based on the general understanding that same-sex partnership or families are not conducive for the well-being of the child. That when a child is upbringing within those non-heterosexual families, they will be subjected to social discrimination and confusion of role per se, without the national judicial authorities, without putting forward proof that in this concrete case, that was the effective effect that's generated on those 3 kids. And that was one of the elements that the court considered in order to overturn the judgment of the Chilean Supreme Court. Because it's true that, for example, right to family life could be restricted. It's true that the right of the mother to have the custody of the children is not absolute. Under certain circumstances, could be restricted, and therefore the custody given to the father. But the question is if the justification provided by national authorities was reasonable enough in order to not amount to a discrimination based on sexual orientation. So the court analyzed those justifications, whether the reasons provided by the national authorities in the final judgment of the Supreme Court were reasonable, were proportionate, and adequate balance the interests at stake. So that was exactly what happened. You have a question?
Actually, it was kind of similar question.
Yeah.
I was wondering if the court asked for an expert report before they made this rule.
Well, here is about which is an important question. It's about the burden of proof. Who needs to prove that a certain limitation of the right is justified or not? Well, and this is applicable to all cases, and it's also what happened before the European Court of Human Rights. What the court does first is to identify if a given situation falls within the scope of protection of a given right. Let's make a very simple design. Let's say that this is Article 11 of the American Convention of Human Rights, which provides protection to family life. The question is if the situation claimed by Ms. Atala-Rifo fell within the scope of protection of the right. That's the first question. Or it falls outside of the scope of protection of the right. For example, someone can say that, please, this is just a very absurd example, but so don't take it very seriously. But it could be. Let's say that someone killed the pet of a given family, and the family went to the judiciary, and the person didn't receive any compensation, and so on, and the case arrived eventually to the Inter-American Court of Human Rights. Not because of the right of the pet itself, this is about human rights protection, but it could be understood that that pet was part of the family life of a given family. That is, it was important for the quality of the life, the family life was a member of the family, and therefore what was affected was the family life of the owners of that pet. Maybe. I never see any case like that. So this is just an intellectual exercise. So the state authorities will say, no, that case falls outside of the protection of the scope of Article 11. So it's not protected by the convention, so you should not discuss it. The defendants, lawyers of the potential victim will say, no, it's within the scope of protection of the right. And therefore we need indeed to discuss. So that's the first discussion that the court will engage with. Is the situation protected within the scope of protection of a given right or not? If the answer is yes, and therefore it's here, then the second question is, has this right been interfered by the decision made by the national authorities? In this case, by the decision made by the Chilean Supreme Court. Has the right of Ms. Atala Rifo to family life, including living with her children, been interfered, been affected by that decision, yes or no? If the answer is yes, then there is a third question that we need to answer. Was that interference justified or not? Because rights could be restricted, but only if that restriction is justified. And then the discussion is about the justiciability of the restriction. Is that clear? And that's what happened in this case. Any question about that or comments? Maybe the camera has one question. It's making noises.
Just a comment that it has happened. That so the Inuit in northern Canada and indigenous peoples, their dogs are a very big part of their lifestyle, and it's part of how they sustain themselves in the north. And as an effort to assimilate them, the Canadian government killed all the dogs, and they've been seeking justice and reparation for the killing of the dogs.
And did the case arrive to the Inter-American Commission?
No.
No.
But just
could eventually. Yeah. So, and I will say, I will build the case in the same way. So, if I will be the lawyer of the Inuit, let's say, I will say that I will argue that that's part of family life, of part of the right to cultural life as well, because those animals are an essential element of the cultural life. So, without the connection with those animals, that given that particular indigenous peoples group will not be able to continue with their own culture in the way that they will like to continue. So it's indeed a very important legal argument. So you see how by interpreting the rights through or within the entire human rights system, you can build a particular claim that could deliver effective protection to minorities. So very good comment. Thank you very much. So at the very end, the court, when decided to resolve these controversies, the court decided to resolve under these four elements. First, the scope of the right to equality and non-discrimination, as we said. Does the situation fall within the scope of protection of the right to equality and non-discrimination, Article 24? Is sexual orientation one of the categories protected by the right of non-discrimination? Is the different treatment based on sexual orientation protected as well? If it was or not different treatment, and finally if that different treatment was justifiable or not, in connection with the interest pursued by the decision made by the national judicial authorities. So this is what needs to be discussed. And to these questions, the court answered that yes, sexual orientation and the right, the decision of a person to live with the partner of the same sex is protected within the scope of equality and non-discrimination. Sexual orientation is one of those categories which discrimination cannot, or distinction in treatment cannot be established. It was indeed a different treatment based on sexual orientation in this case, because the decision of the judicial authorities in Chile were based on a stereotype understanding of the role of Ms. Atala as a mother, that she's supposed to not be with the partner of the same sex, because that will not be conducive for the upbringing of the 3 children. And finally, to the fourth question, if that was justified or not in connection with the risk of the best interest of the child, the court provided a negative answer. I say, well, it's true that in some cases the best interest of the child could limit the protection of the right to family life, for instance, but that need to be specifically justified in concreto, cannot be justified in abstract. So the statement made by the judicial authorities in Chile did not prove that the children were at risk by living with Ms. Atala Rifo and her partners. And even another principle on the best interest of the child, that is to hurt the children in any case that affect them, was not followed by the judicial authorities. So the children said that they want to live with the mother, but the judicial authorities didn't pay any attention to that statement. And therefore, their best interest didn't consider their own position and opinion. And in that sense, the court found that the limitation was not justified, and therefore was a violation. If you want to know more about this case, you can download the case. Before going to the break, we have a short break of 5 minutes. Do you have any question or comments about this case?
I would.
We have two. Let's start here and then we come back to you.
I was just wondering if the sex of the children was considered to be important for the case, because I just saw that it was girls and not boys, and I'm just wondering if it would have been boys and not girls, if the father would have made this lawsuit in the first place. Did this have any impact on the case?
Not as far as I understood, because what the court considered is that the justification provided by the judicial authorities in Chile that growing up in a same-sex family will generate a confusion of gender roles for the children, the male and the female role, because they do not have a male role as an adult within the family, was just a stereotype affirmation without any scientific proof. So the court said judicial authorities were unable to establish which was the effective risk that the children will encounter by living with the same-sex partner, but didn't explore the fact that they were girls instead of boys. So they take it as children and potential confusion of roles, and stop there. Say, well, the burden of proof is on national authorities. They couldn't prove that this would generate a risk. But they say something else as well. They said that in connection with the argumentation that children will face discrimination in society because the fact that they will be raised in a same-sex partner will generate a stigma on them in connection with the other children in school, said, well, you cannot justify a distinction of treatment based on a discrimination. In other words, you cannot use a discrimination in order to generate a new discrimination. So the fact that in society, individuals that have a different sexual orientation are discriminated cannot be used as a justification to generate a new discrimination. So it says that that was not a valid argument. On the contrary, state authorities need to address that systemic situation in which a person of a different sexual orientation than the heterosexual mainstream situation in society are discriminated. They have to do something about it instead of using as an argument to restrict the enjoyment of other rights. So, but no, they didn't discuss that.
Yes, my question is related to that of the previous speaker. That the justification was based, as you just said, based on a stereotype. And it was not asked to provide evidence. Wow, this is very shocking to me, because we can come up with all sorts of stereotypes and provide judgments which support them. So, and if you compare this judgment with what happened in Ireland, around the referendum running up on the same-sex marriage, it was the first country that by a referendum approved same-sex marriage. What was amazing that it was all based on evidence. So you saw documentaries on the television, children brought up by same-sex parents were asked very delicate questions exactly about confusion of the roles, for instance about youngsters who were brought up by two lesbian parents. You know, a young man was asked, so are you too gay? He said, no, not at all. I'm heterosexual. It's not. So all kinds of, but I think it is very, very important, the transformational role of the law to achieve equality. So it's very interesting to me that you can see the law as reconstructing and reinforcing stereotypes without even asking or asking for evidence. That I find a little bit shocking. The question is, of course, shocking. Dramatic language, it happens. But the thing is that, has anything changed since 2012 on this in Chile?
The law didn't change. So they didn't introduce a recognition of same-sex partnerships or the recognition of enhanced rights for sexual orientations, different sexual orientation groups or different gender identity. So it's quite conservative so far.
And advocacy, civil society advocacy has been
Yes.
done around?
Well, at least in that sense, it's a democratic country, so the civil society groups advocating for these LGBT rights, they are not criminalized, they are not persecuted, so they have a space in society, but the society is very conservative. The views of the society.
Yeah, nonetheless, Latin America is one of the most powerful drivers of human rights.
Yeah.
So it's not well known, but without Latin America, we wouldn't be where we stand now.
Absolutely.
Because civil society in Latin America and Mexico, for instance, they were extremely powerful. I'm just making this point because it's not well known, and I think it's Catherine Sicking, a very leading international relations scholar on human rights. He just published a book, Evidence for Hope, in which she emphasizes, goes against the also claim that human rights is of European origins, pointing and demonstrating, bringing evidence of the Latin American input, enormous input into the making of human rights. Yeah.
But thanks for that. I think you're absolutely right. Civil society has been behind most of these cases. And in particular, we see it after this very short break that we have, in particular in cases of indigenous people rights. All of them were brought by civil society organizations, law clinics, with support even with law clinics based in the United States. The first case happened in that way. So civil society with legal advocacy capacity has been instrumental for the development of these rights. Now, talking about what happened at the national level, now we have a different scenario because, and with this we will finish this blog, in 2010, January this year, a new advisory opinion was adopted by the Inter-American Court. It's only available in Spanish, but soon will come in English as well, on gender identity. And Costa Rica, the state of Costa Rica, has different questions about it. Let me see if I have it here. I want just to go quickly on that. No. You see, I'm very, this is, here it is. I think this is the advisory opinion, 2417, was issued now in January, and Costa Rica has about gender identity, equality and non-discrimination with the right of same-sex couples, and the obligation of the state to change names in connection with the gender identity, and to provide certain kind of recognition to same-sex partners. So it was a very broad advisory opinion. don't have the time to go through, but I recommend what will be available in English to read it. Because it's long as well, 167 pages, something like that. But it's a very interesting advisory opinion because the court concludes that according to today's evolution of the inter-American system, according to how today we interpret the convention, all states part of the convention, not only Costa Rica that requests the advisory opinion, but all states, because this is an interpretation of the standards within the system, has the obligation to provide recognition of gender identity as perceived by the person that requests. So it's self-perceived gender identity, and has the obligation to change the names within official documents without mentioning the change of the identity in order to spare any allocation of blame on the person. So that's one point. Now, in the Americas, within the state parties of the American Convention, they have to recognize the different identities and provide legal documents in accordance with that identity, including states that are very reluctant to that. So that's the new standard as recognized by the court. And secondly, and this is the most interesting part, according to today's evolution of human rights law, states are obliged to provide recognition without discrimination of same-sex partnership in connection with heterosexual couples. They cannot provide less protection than the protection provided to heterosexual couples, including marriage. And this is the most controversial part. Because the court says that non-discrimination based on sexual orientation is the current standard. And if you have institutions within your legal system that provide protection to families, and within the scope of families, same-sex partnerships are included, then you cannot discriminate by not providing the same institutions to same-sex partners. And that means that if you recognize marriage to heterosexual couples, you have to recognize marriage to non-heterosexual couples. But, and this is the only flexibility that the court recognized, the court says that because, and the standard is very difficult in certain countries to introduce that change, it will accept for the time being the non-recognition of same-sex marriage to same-sex partners, as long as other form of protection will provide the same level of rights. And this is valid also for Chile and any other country within the region. What will happen with this development? We don't know. What happened in Costa Rica, for example, and with this we finish for 2 minutes, is that came out within the election of the new president. And it was a candidate that was advocating for a very traditional family life standard. He was a former evangelical pastor. And his chances for being elected as a president were only 3 and 9%. When this came out, and the first round of elections came after this, his vote rocketed to 25%. From 3% that was expected to 25%. And then he went to the second round with the second most voted candidate, that was from the Socialist Party. And at the second election, this candidate lost. But it was very, 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 very close to win the presidential election. And he said if he will win, the first things that he will do will be to denounce the American Convention, to take Costa Rica out of the system, because he cannot accept that the court recognized rights to same-sex partners as he did. So you see very strong reactions. But fortunately, that person was not elected. At least what the Costa Ricans decide, and therefore Costa Rica remained within the system. But what I wanted to say is that these developments sometimes go so far that for the society it's difficult to digest it. And indeed, that will happen in certain states within the Americas. Let's have a break of 2 minutes, so you can...
Sorry, we just
yes.
have less than 15 minutes before lunch, so maybe if you
No
don't
break.
object, we can just finish.
Very good. Then just you can stretch yourself 2 seconds meanwhile I go to the next thing. Let me go a little bit.
You'll cut a short break in these first
Yeah.
sessions.
Yeah, because it's important.
Yeah, I just.
So this is
The next, but will be very short, unfortunately.
yeah.
Very good. Did you stretch yourself a little bit? I did. Indigenous people in the Inter-American system, there is a lot to say about it. I wrote a book about it, I've written articles about it, there's a lot to say. But if you want to watch a very interesting video, go to YouTube and you will find this video on Sarayaco indigenous people and Amnesty International, where they documented what happened with this case. This was a case, Sarayaco indigenous people against Ecuador, that was adjudicated by the Inter-American Court of Human Rights in 2012. And this was one of the cases, series of cases, in which the Inter-American Court of Human Rights recognized the right of indigenous people. Here is interesting because you will see how the history developed from the eyes of indigenous people themselves. How do they perceive all this long path from facing the challenges introduced by the exploitation of natural resources in their traditional land, to going through the judicial system and arriving to San Jose, going to an audience with the judges in Costa Rica, and then receiving the final judgment in their favor. Very interesting documentary. We don't have time, but you can find it in YouTube and watch it. I think it's called The Children of the Jaguar, Amnesty International. So just type it and find it. Different cases. Now we have a marathon. Are you ready to run? Because we have only 10 minutes to finish. I will not talk about all of that. But the cases of indigenous people's rights and the recognition of the rights started in 2001. That was the first judgment issued by the Inter-American Court of Human Rights in the case of Mariana Sumo Aguastini Community versus Nicaragua, and where you find the first separate opinion of Judge Cansado Trindade, where he started writing his interpretation of the right of indigenous people. And in all of the cases regarding indigenous people that he took part of, you will find his separate, concurrent, or dissenting opinions. Very interesting ones. But then in the later cases, of course, he was not part of the court, but the jurisprudence continued the same development. We have more cases, but in 2012, 2014, but I don't have it. What was the essential way to recognize indigenous people's rights? Right to property. And you will say, right to property, that's not connected with what we understand about indigenous people. But you see, everything is about interpretation. How we use one particular right, Article 21 of the Inter-American Convention, to provide protection to indigenous people's rights. This is Article 21, paragraph 1. Everyone has the right to use and enjoy an enjoyment of his, should be property. But the law may subordinate that enjoyment. So, right to property is not an absolute right, could be restricted. But the interpretation provided by the Inter-American Court says something completely different. It says that within the scope of protection of Article 21, let's change this, we put 21 here. Within the scope of protection, we found the spiritual and material elements and that are connected with the special relationship that indigenous peoples has with their land. Is that included in the text of the article? Of course not. This is just an interpretation made by the court. Say, well, when we understand property, remember the Vienna Convention of Law of the Treaties, the terms of the treaty need to be interpreted under the light of the object and purpose of the treaty. Effective protection of human rights. For indigenous peoples, right to property doesn't mean the right to property as recognized in the civil code. Doesn't mean something that you can buy and sell according to the price of the market. For indigenous people, property means something different. The interrelation between them with their lands has a different dimension. But that is also protected under the idea of property. Because the court said, well, the rights of the convention cannot be interpreted under the interpretation of national laws, or how we interpret institutions in national law. The concept of a convention are autonomous. So what we understand of property under the American Convention is not the same as it is understood within the Chilean legal system, the Argentinian, the Brazilian, etc., etc. So it's an autonomous regional understanding. How the court arrived to that? Through an evolutionary interpretation. So the court said, well, today, indigenous people rights are part of international human rights law. They are protected. They are part of human rights. We cannot preclude or interpret the rights of the convention as the way of restricting other rights. And if we interpret property as just only a commodity, we will exclude others from the enjoyment of this right. So we cannot do that. Therefore, we have to include property as including the communal understanding of property, and as including the spiritual and material dimension of lands that indigenous people have. Here is the quotation from the first case resolved by the Inter-American Court of Human Rights. And here you find a specific quotation in which we found the principle of effectiveness, or effectivity. So, disregarding specific form of use and enjoyment of property, based on different cultures, for example, of each community, will be a tantamount to holding that there is only one way of using and disposing of property, which in turn will render protection of Article 21 of the Convention illusory for millions of people. Effectiveness. We cannot interpret the Convention in a way that will exclude from the protection the people that's supposed to protect. So, principle of effectiveness. Another case, the Josamasa Indigenous Community versus Paraguay, 2006. Very interesting case. This was a case of a community living alongside of a road in Paraguay because they were expelled from their traditional lands that were in the hands of private owners. Since more than 100 years, Paraguay sold these lands to private owners, but with indigenous peoples living on them since centuries. But their rights were not recognized at the time, and one day, private owners expelled them from their lands, and they started living alongside of the road near to the property where they used to live. And that generated even the death of many of them, including children, because they didn't have any services. National authorities knew that they were living there, that they were expelled from the property, but did nothing. Not even in order to provide the minimum health care protection to children or others in situation of vulnerability. So it was a very tremendous case, but recognized the right of these people to their traditional rights. I think I will go just to the very final slide, and I will explain something that I want to share with you, and then we can have questions about it. Let me see if I find it. Here we are. This is my interpretation of the jurisprudence of the Inter-American Court of Human Rights in connection with indigenous people rights. Let me explain what does it mean. So, we said that indigenous people, let's see if, we have this. So, indigenous peoples has a special connection or relation with their traditional lands. And that was recognized by the court, as we saw within that jurisprudence. That special relation has two components, spiritual and material. Spiritual because they, in that relation, they found their own way of understanding the world, their own spirituality, their own religiosity, their own world views. Material because it provides means of subsistence. That relation also is intimately connected with their own identity, with their cultural identity. So the way that they see themselves and the way that they recognize themselves is intimately connected with that special relationship that we have with their lands. That cultural identity is essential for the enjoyment of the right to life. Remember, right to life has two components under the jurisprudence of the Inter-American Court of Human Rights. One is the protection against deprivation of life. So, nobody should be deprived of his or her own life arbitrarily. But the second one is about the possibility to develop the conditions according to his own or her own project of life. In other words, the possibility to have dignified condition of life. State authorities are responsible, according to the Inter-American Court of Human Rights, to develop those conditions. State authorities need to create the conditions in society that will be conducive for every individual to develop his or her own project of life. What does it mean for indigenous people? Well, it means that for them to have a dignified life, need to be connected with the cultural identity, which is connected with the special relationship with their lands. State has positive obligations to protect right to life and cultural identity, and in order to do that in connection with indigenous people, they need to provide the legal instruments that will allow them to have access to their traditional lands as protected under right to property. That means providing recognition of their titles, providing recognition of the right to use and enjoy those lands, and provide protection against interference coming from state authorities or from private owners. Therefore, in order to protect life and identity, state authorities need to provide the protection of the connection with their lands. What does it mean if we have a conflict with other interests? What does it mean if private owners want to exploit or have a claim of property over the same land? Or the state authorities will give concessions to exploitation of minerals or other natural resources? Well, when we balance rights, those that will advocate for the protection of indigenous people rights, they need to put in the balance also the protection of right to life and cultural identity. It's not only a balance between two different property rights. It's not only the balance of private property rights against communal property rights. If you add protection of right to life and cultural identity, the balance will change. And then you will be in your case. Questions, comments? Oi, too much. Yes. We have 2 minutes and a half. And then we have over there. So start here and then we go to you.
Is it regarding this? Because I'm going to jump.
No,
Because I'm going to jump out of the topic.
Then let's start this and then we come back to you. Thank you. Thank you for saying.
I was about to ask you before you started with this topic if, sorry if I don't use the correct legal terms because I'm not a lawyer. If in sentences and in these cases the right to life is also mentioned, but now it's just a comment because I know that the Guarani have this concept of tecoa, which is their land, but not only the physical land.
Yeah.
There's also the spiritual element of the land, and it's also associated to life itself. So for them, if you don't have the tecoa, you don't have life, and you are not a Guarani.
Yeah.
Yeah, just a comment.
Yeah, no, it is connected indeed. So you will find it in the jurisprudence, absolutely.
Thank you. My name is Maria from Spain. I was just encantada. I was just wondering what is the role of the Inter-American Commission of Human Rights on regarding activists and defenders of human rights, minority rights. For example, also the case of Marielle Franco recently from Brazil.
Mm-hmm.
What is the position that has been taken? Or
Yeah. It's connected with these cases as well, because unfortunately human rights defenders has been targeted different places, not only by state authorities but by private agents because they work. And in particular in connection with indigenous people's rights and the protection of their rights, as I said, civil society has been absolutely instrumental for that. And that means human rights defenders has been targeted by others that have different interests over the same land. And the Commission has paid a lot of attention. The Commission has its own police enforcement body, so it cannot deliver any protection within the land to a particular human rights defender at risk. But through provisionary measures, has ordered state authorities to provide protection to human rights defenders. And it has issued specific reports. The last one, if not the last report of the human rights thematic report of the Commission is on human rights defenders and the protection in the region. So the Commission has been very keen on provide awareness of their situation and provide a forum in which the conditions could be discussed. But unfortunately, it has very limited capacity to provide protection on the ground, because the Commission has no competence. The Commission cannot even visit the country without the invitation of the country, as it happened with any treaty body. They can go in their own individual capacity, but as a Commission, the countries need to extend an invitation. Could be a standing invitation, like in the treaty bodies, where it's an open invitation, at any time they want, they come, or, for example, in the case of Venezuela, there is no invitation, so they cannot visit the country. And unfortunately, that is a limit for what they can deliver as a protection. In certain cases, when the countries did not follow the provisionary measures of the Commission requests the court to issue a binding order for the protection of the right, when the court is part of the country is part of the convention. And that has been delivered better results. But even in certain cases, countries do not follow even the order of the court. So there is a non-compliance with a binding order. So unfortunately, if you read the reports, the human rights defender has been targeted and murdered. And it's a current problem within the region. But at least the focus is on their protection, at least. Yes?
So I was a bit surprised when I saw the list of the cases which were related to indigenous peoples, and that the majority of the cases were against Paraguay, is that right? Because I wonder what's the reason behind it, because yesterday, for example, Ellen Weiss, the director of the European Roma Rights Center, said that only 1% of the cases before the European Court of Human Rights were initiated by Roma people, which is very surprising given that the Roma are the most marginalized minorities in Europe. So I wonder what's the reason behind it. Maybe because the civil society is very strong in Paraguay, or there were more cases of human rights violations against the indigenous people?
Well, there are cases of violations all over the region in case of indigenous people. For example, we have issues in Argentina, but we still don't have cases against Argentina. We have issues in Brazil. We have just only one case 2 years ago. We have cases in Chile. We don't have cases that has been adjudicated again, not on right to property, but yes, on human rights defenders in Chile in connection with indigenous people rights. So there is a mix of reasons. One is the lack of civil society organizations active defending indigenous people rights in that given country, and having the possibility to litigate all the way with resources available, because it's costly. Indigenous peoples communities per se, in most of the cases, without their support, they don't have the knowledge of their rights and the instruments that they can use in order to protect their rights. So they basically are engaged in battles, but without that institutional, without the capacity support. So the first case, for example, I was thinking, they came because law clinic from one American university was conducting investigations, research in the region, and decided to test the case as a leading case within the inter-American system, using their own capacity and their own funds. So they provided all the institutional support in order to indigenous people to arrive to the inter-American system. So the most common reason is lack of knowledge, lack of resources, because indigenous peoples are the poorest among the poor. And therefore, lawyers and legal aid within the countries in general, they are not also available. So unfortunately, there is no enough institutional support. That is the main problem. Any final question, comments, please?
Thank you. I would like to go back to the terms of procedure in of the cases in the court.
Yes.
Does court have any term exceptions for urgent cases? For example, European Court of Human Rights has an exclusive terms for procedure for the cases that are directly connected with the danger to life or national hate speeches. Does the court has any?
No, what it has is the provisionary measures, so the court can take urgent measures even outside of a case. So remember that the case, in order to be adjudicated by the court, needs to be submitted or referred by the Commission. So the case goes first to the Commission issues the decision with final recommendation, and if those recommendations are not followed by the state, then the Commission will refer the case to the court. But the court, even if the case is not before already referred, but is on the Commission, the court could issue provisionary measures for protection of urgent cases. And those decisions issued by the court has binding effect. So the person in question, or the group in question, will be protected, meanwhile the case is going on at the Commission level. The court can never take a case from the Commission. There is even an advisory opinion of the court recognizing the autonomous power of the Commission. So the case has to go through the Commission and then to the court. And of course there is right to defense for the state authorities and so on. So, but the court can intervene at any moment with the urgent measures to protect a right. And those are binding obligations for the state authorities. So if it's about protection of right to life, protection of any right, the state authorities need to follow the order of the court. Otherwise, it's a violation of international law. The court cannot send police, because it has no police. It has no any enforced authority to send a given body to effectively act at the national level. So the only way to enforce orders by the court is through the cooperation of national authorities. Without that cooperation, there is no system. Unfortunately, that's the reality. Any other question, comments? Otherwise, I think this is quite good for being Latin American. We are only 10 minutes delayed. So it's quite good. I'm quite happy. Thank you very much for your participation. Thank you for being part of this discussion. And let me see if I have my email address. Here is my email address. If you want to continue the discussion, please send me an email. I'm available through internet, through my email address, so we can continue. And I wish you all the best. And this is the best way to develop your own skills and capacity. To expose yourself to other realities, to the knowledge of other colleagues and people coming to you, and explore all the possibilities. So never stop doing that, because you will arrive very far. Thank you very much.